Welcome to Supreme Court Opinions. In this episode, you'll hear the court's opinion in Gutierrez v. Saenz. In this case, the court considered this issue. Does a Texas death row inmate have standing to sue the state over its refusal to grant access to DNA testing under a law that allows such testing only when the person can demonstrate that exculpatory results would have prevented their conviction? The case was decided on June 26, 2025. The Supreme Court held that Petitioner Ruben Gutierrez has standing to bring his 42 U.S.C. Section 1983 claim challenging Texas's post-conviction DNA testing procedures under the Due Process Clause. Justice Sonia Sotomayor authored the majority opinion of the court. Prisoners convicted in state court have a liberty interest in demonstrating their innocence with new evidence under state law. When states create post-conviction procedures, they can create rights to other procedures essential to realizing those rights. Under Skinner v. Switzer, a prisoner may bring a Section 1983 due process claim alleging that a state's DNA testing statute unconstitutionally prevents him from obtaining testing, even though he cannot directly challenge state court denials of his testing motions. To bring such a suit, the prisoner must demonstrate judicial standing to sue. The standing analysis follows Reed v. Gortz, which requires three elements. First, Gutierrez adequately alleged an injury, the prosecutor's denial of access to DNA evidence. Second, Prosecutor Saenz caused this injury by refusing to release evidence in his custody for testing. Third, if a federal court declares Texas's procedures unconstitutional, that judgment would eliminate Saenz's justification for denying testing, thereby removing the barrier between Gutierrez and the evidence. The declaratory judgment would change the party's legal status and redress Gutierrez's injury by eliminating the allegedly unlawful basis for the denial. The Fifth Circuit erred in two fundamental ways. First, it improperly focused on the limited declaratory judgment the district court ultimately issued rather than on Gutierrez's broader complaint. Gutierrez's complaint challenged not just Article 64's limitation to actual innocence claims, but multiple barriers the statute creates, including its virtually insurmountable standard for parties to crimes, its refusal to consider new evidence, and its prohibition on testing solely to challenge death eligibility. Standing depends on the allegations in the complaint, not on the particular relief a district court later grants. Second, the Fifth Circuit wrongly transformed the redressability inquiry into speculation about whether the prosecutor would ultimately provide the evidence. Under Reed, a declaratory judgment need only eliminate the prosecutor's reliance on the challenged provision as a justification for denying testing. The court rejected the notion that redressability requires certainty about the ultimate outcome. That a prosecutor might find other reasons to deny testing, just as the prosecutor in Reed had multiple grounds for denial, does not defeat standing to challenge specific reasons as unconstitutional. Courts regularly allow plaintiffs to challenge improper legal grounds for discretionary decisions even when the decision-maker might reach the same result for different reasons. Justice Amy Coney Barrett joined all but Part 2.B.2 of the majority opinion, and authored a concurring opinion arguing that the court should have reversed based solely on the Fifth Circuit's failure to consider the full scope of relief requested in Gutierrez's complaint. Justice Clarence Thomas authored a dissenting opinion, arguing that the court lacks authority to intervene because state-created post-conviction procedures cannot create liberty interests under the Due Process Clause's original meaning. Justice Samuel Alito authored a dissenting opinion, joined by Justices Thomas and Gorsuch, arguing that the majority distorts the Reed standard and that Gutierrez cannot show his injury would be redressed given the Texas court's multiple independent grounds for denying DNA testing. The opinion is presented here in its entirety, but with citations omitted. If you appreciate this episode, please subscribe. Thank you. Justice Sotomayor delivered the opinion of the court. For nearly 15 years, Petitioner Ruben Gutierrez has sought DNA testing of evidence that, he says, will help him prove he was never at the scene of the murder he was convicted of committing. When the local prosecutor refused to test the evidence in his custody, Gutierrez filed suit under Section 1983, arguing that Texas's procedures for obtaining DNA testing violated his rights under the Due Process Clause. The district court agreed and granted a declaratory judgment to that effect. The Fifth Circuit, however, held that Gutierrez lacked standing to bring his Section 1983 suit, reasoning that, even if a federal court declared Texas's procedures unconstitutional, the local prosecutor would be unlikely to turn over the physical evidence for DNA testing. That holding contravenes Reed, where this court decided on analogous facts that another Texas prisoner had standing to sue the local prosecutor who denied him access to DNA testing. Put simply, Reed held that a federal court order declaring that Texas's post-conviction DNA testing procedures violate due process would redress the prisoner's claimed injury by eliminating the state prosecutor's reliance on Article 64 as a reason for denying DNA testing. The same is true here and the court therefore reverses. In 1998, Texas charged Ruben Gutierrez with capital murder for the killing of Escholastica Harrison at her mobile home in Brownsville, Texas. The state's theory at trial was that Harrison had been stabbed to death with 2 different screwdrivers. To support its view that Gutierrez wielded one of the 2 screwdrivers in question, the state introduced a statement Gutierrez gave to the police, in which he acknowledged that he and 2 accomplices had planned to rob Harrison on the day she was killed, and that he had been in Harrison's home while one of his accomplices stabbed her. The jury convicted Gutierrez of capital murder. Texas law provides that a criminal defendant can be guilty of capital murder even where he was merely a party to a crime, such as robbery, that resulted in a person's death. A death sentence, however, may be imposed only if the defendant actually caused the death of the deceased, intended to kill the deceased, or anticipated that a human life would be taken. To that end, the jury was required at the sentencing phase of Gutierrez's trial to answer whether Texas proved beyond a reasonable doubt that Gutierrez actually caused Harrison's death or, if not, that he intended to kill her or anticipated that a human life would be taken. The jury answered yes, and Gutierrez was sentenced to death. Gutierrez has long maintained that the police coerced him into confessing that he was in Harrison's home on the night of the murder. He insists that, as he twice told the police before the statement in which he purportedly confessed, he never entered the mobile home that night. Although Gutierrez never disputed that he and 2 accomplices planned to rob Harrison, he contends that he thought his accomplices would merely rob Harrison's empty mobile home and that no one would be harmed during the robbery. He accordingly asserts that he should never have been sentenced to death, and intends to seek vacatur of his death sentence in a state habeas petition. Since 2010, Gutierrez has sought DNA testing of crime scene evidence, including Harrison's nail scrapings, a loose hair, and various blood samples, to help him prove it was his accomplices, not Gutierrez, in Harrison's home on the night of her murder. He maintains that Texas's Article 64 entitles him to such DNA testing. That law provides for DNA testing where a convicted person establishes by a preponderance of the evidence that he would not have been convicted if exculpatory results had been obtained through DNA testing, and that the request was not made to unreasonably delay the execution of sentence or administration of justice. To grant a motion for DNA testing under Article 64, the state court must also find, among other things, that the evidence is in a condition making DNA testing possible and that identity was or is an issue in the case. Invoking Article 64, Gutierrez twice moved in state court for an order requiring the local district attorney to turn over the untested crime scene evidence for DNA testing. The trial court denied his first request in 2010, and the Texas Court of Criminal Appeals, TCCA, affirmed. The TCCA reasoned that, even if Gutierrez's DNA was not present on the tested items, that would not establish his innocence of Texas capital murder. After all, even if he was not in the home, Gutierrez could still be a party to the robbery that eventually resulted in Harrison's death. And, as the TCCA saw it, Gutierrez could not invoke Article 64 to establish that he had been wrongly sentenced to death unless he could also establish his innocence of the underlying crime. Finally, the court added, even if Article 64 did apply to evidence that might affect the punishment stage as well as conviction, Gutierrez still would not be entitled to testing because the record facts show that he played a major role in the underlying robbery, and that his acts showed a reckless indifference to human life. Gutierrez tried again in 2019, this time bolstered by new counsel and new evidence that, according to Gutierrez, would implicate Harrison's nephew, Avel Queller, as one of the 2 people who stabbed Harrison to death. In the interim, Fermin Queller, Avel Queller's nephew, had signed a sworn statement averring that his uncle Avel approached him in the summer of 1998 about stealing a lot of money from Harrison. Fermin also averred that, after the murder, Avel boasted to Fermin that he had money buried in the trailer park. Again, the Texas courts denied Gutierrez's motion. On appeal, the TCCA reiterated that DNA testing was not available to show ineligibility for the death penalty, and that, even if it were, Gutierrez still would not be entitled to testing. Gutierrez next filed this federal action for declaratory and injunctive relief under Section 1983. He sued Respondent Luis Saenz, the district attorney who has custody of the evidence Gutierrez would like tested and whose office prosecuted Gutierrez. Gutierrez's complaint alleges that, by refusing to release the biological evidence for testing, and thereby preventing Gutierrez from gaining access to exculpatory evidence that could have led to his acquittal, or demonstrated that he is not death eligible, the district attorney deprived him of his liberty interests in utilizing state post-conviction procedures, in violation of his right to due process of law. Gutierrez's complaint pinpoints at least 3 features of Article 64 that prevented him from gaining access to the relevant evidence to which, he says, the Due Process Clause entitles him. First, Gutierrez says, The Texas courts interpret Article 64 to impose a virtually insurmountable barrier to obtaining DNA testing, deeming a prisoner ineligible as long as the record contains any evidence, no matter how minor, that he committed the crime. Second, and relatedly, he asserts that it was unfair for the TCCA not to consider new evidence he had proffered since his trial. A fair procedure, he contends, would require considering the effect exculpatory DNA evidence would have on a jury that also heard new evidence casting doubt on Gutierrez's statement to the police. Third, Gutierrez asserts that, as interpreted by the TCCA, Article 64 violates the Due Process Clause by forbidding DNA testing when its sole purpose is to establish that a defendant is ineligible for the death penalty. The district court agreed with Gutierrez in part. It is fundamentally unfair, the court declared, that Texas gives prisoners the right to file a habeas petition challenging their death sentence, but precludes them from obtaining DNA testing to support that habeas petition unless they can establish innocence of the underlying crime. That limitation renders the habeas right illusory because few people can make a clear showing that they were wrongly sentenced to death without DNA evidence. Due process, the court explained, does not countenance procedural sleight of hand whereby a state extends a right with one hand and then takes it away with another. On appeal, a divided panel of the Fifth Circuit vacated the district court's declaratory judgment, reasoning that Gutierrez's claimed injury was not redressable because the declaratory judgment would be unlikely to cause the prosecutor to reverse course and allow testing. The court recognized that, just 2 years ago, this court rejected a nearly identical argument in Reed. Yet the Fifth Circuit purported to distinguish Reed because, in Gutierrez's case, the TCCA effectively anticipated an unfavorable federal court ruling when it held that, even if Article 64 applied to claims affecting death eligibility, the facts in the trial record would still not entitle Gutierrez to DNA testing. Judge Higginson dissented, noting that he saw no meaningful distinction between this case and Reed. While Gutierrez's request for rehearing was pending in the Fifth Circuit, Texas scheduled his execution. This court stayed his execution and granted certiorari to consider Gutierrez's standing to bring his Section 1983 claim. Because Reed plainly establishes that he does, the court now reverses. Individuals convicted of crimes in state court have a liberty interest in demonstrating their innocence with new evidence under state law. For that reason, a state-created right to post-conviction procedures can, in some circumstances, beget yet other rights to procedures essential to the realization of the parent right. To that end, this court held in Skinner that a Texas prisoner could file a due process claim under Section 1983 against a prosecutor who refused to release biological evidence for testing. In that case, Skinner had alleged that the prosecutor's refusal to turn over evidence deprived him of his liberty interests in utilizing state procedures to obtain reversal of his conviction and/or to obtain a pardon or reduction of his sentence. This court reasoned that, while Skinner could not challenge in federal court the TCCA decisions denying his Article 64 motions, he could allege in a Section 1983 action that Article 64 unconstitutionally prevented him from obtaining such testing. Skinner did not explicitly address a state prisoner's standing to bring a due process claim against the custodian of his evidence. That question was first raised in Reed, where this court confronted another claim that Texas's post-conviction DNA testing law failed to guarantee procedural due process. Rodney Reed alleged, among other things, that Article 64's stringent chain of custody requirement was unconstitutional, and in effect foreclosed DNA testing for individuals convicted before rules governing the state's handling and storage of evidence were put in place. Before this court, the local prosecutor argued that Reed lacked Article 3 standing. Specifically, the prosecutor asserted that a favorable court decision would not redress Reed's injury. That was because, in the prosecutor's view, a federal court's declaration that the statutory provision he attacks is unconstitutional would not likely cause the district attorney to turn over the physical evidence in his possession. This court disagreed and held that Reed had established standing to pursue the declaratory judgment action. First, the court explained, Reed sufficiently alleged an injury in fact, denial of access to the requested evidence. Second, the state prosecutor, who is the named defendant, denied access to the evidence and thereby caused Reed's injury. Finally, the court reasoned, if a federal court concludes that Texas's post-conviction DNA testing procedures violate due process, that court order would eliminate the state prosecutor's justification for denying DNA testing and thereby remove the barrier between Reed and the requested DNA testing. The same is true of Gutierrez's suit. Like Reed and Skinner, Gutierrez alleges that the local prosecutor's denial of his request for DNA testing deprived him of his liberty interests in utilizing state procedures to obtain an acquittal and/or reduction of his sentence, in violation of his right to due process of law. As in Reed, moreover, The declaratory judgment Gutierrez seeks would redress that injury by ordering a change in the legal status of the parties and eliminating the state prosecutor's allegedly unlawful justification for denying DNA testing. That is sufficient to resolve this case. The Fifth Circuit recognized the clear parallels between this case and Reed. Nevertheless, the court thought that, unlike in Reed, the local prosecutor here was unlikely to allow testing even if a federal court declared Texas may not deny DNA testing that would affect only the punishment stage. Because the TCCA already concluded Gutierrez would not be entitled to DNA testing even if Article 64 did apply to evidence affecting only the punishment stage, the Fifth Circuit reasoned that the district attorney would quite likely rely on that holding to deny testing again. Respondents, joined by the principal dissent, similarly urged that Gutierrez lacks standing because the district court's reason for declaring part of Article 64 unconstitutional was only one of several independent state law grounds supporting District Attorney Saenz's decision to deny access to the requested evidence. This attempt to distinguish Reed is wrong twice over. First, both respondents and the Fifth Circuit gloss over the substance of Gutierrez's complaint, which is the proper focus of the standing inquiry here. Gutierrez's complaint takes issue not just with Article 64's limitation to actual innocence claims, but with the barrier Article 64 erects between Gutierrez and DNA testing. At bottom, Gutierrez asserts that, to the extent Texas law precludes him from obtaining the requested evidence, it violates his rights under the Due Process Clause. That is why his complaint alleges, among other things, that Article 64 poses a virtually impossible standard for anyone convicted under the law of parties to obtain DNA testing, and why he takes issue with the TCCA's refusal to consider newly proffered evidence in assessing claims like his own. To the extent the Fifth Circuit based its assessment of redressability on the declaratory judgment the district court later issued, rather than Gutierrez's complaint, it turned the Article 3 standing inquiry on its head. Gutierrez's standing to bring this suit does not depend on the relief the district court granted on the merits. The principal dissent does not dispute that Gutierrez challenged, in his complaint, each of the roadblocks Article 64 placed between himself and DNA testing. Instead, the dissent repeats the Fifth Circuit's error, urging that Gutierrez can now obtain only reinstatement of the district court's declaratory judgment. But rather than assert that the scope of the declaratory judgment retroactively deprived the district court of jurisdiction over Gutierrez's complaint, as the Fifth Circuit erroneously held, the principal dissent suggests instead that affirmance of the district court's declaratory judgment would not help Gutierrez moving forward. That argument, however, does nothing to support the Fifth Circuit's holding, which the principal dissent defends, that Gutierrez lacks standing to bring this suit. Second, and more fundamentally, the Fifth Circuit erred in transforming the redressability inquiry into a guess as to whether a favorable court decision will in fact ultimately cause the prosecutor to turn over the evidence. In Reed, just like in this case, the Texas courts had proffered multiple reasons for denying Reed's Article 64 motion, including that Reed did not demonstrate that he would have been acquitted if the DNA results were exculpatory, and that Reed failed to establish that his request was not made to unreasonably delay the execution of his sentence. The principal dissent claims that, for Reed, striking down the chain of custody rule would have critically undermined the TCCA's holding as to 21 additional items, which could have been considered if the declaratory judgment issued in his favor. Yet even absent the chain of custody rule, Reed still faced the TCCA's assessment that his DNA testing request was untimely, and the trial court's determination that exculpatory results from DNA testing of all the evidence he requested to be tested would not establish his innocence. This court nevertheless reasoned in Reed that, if a federal court concludes that Texas's post-conviction DNA testing procedures violate due process, that court order would redress his injury by eliminating the state prosecutor's reliance on Article 64 as a reason for denying DNA testing. The particular declaratory judgment Reed requested was thus no more likely to yield a change in the district attorney's conduct than the one Gutierrez sought here. What was true in Reed thus applies here too. There is little doubt that Saenz considers Article 64 in his assessment of whether to provide requested DNA evidence. Indeed, Saenz confirmed at oral argument that he would likely turn over the evidence if he thought Article 64 entitled Gutierrez to DNA testing. A declaratory judgment in Gutierrez's favor would accordingly redress his injury by removing the allegedly unconstitutional barrier Article 64 erected between Gutierrez and the requested testing. To be sure, Saenz nevertheless states that any declaratory judgment will not affect his ultimate willingness to turn over the evidence. He and the principal dissent urged that the court need not even speculate about what he might do because, after securing a declaratory judgment from the district court, Gutierrez again sought DNA testing and Saenz refused. This, again, is a familiar refrain. The prosecutor in Reed, too, maintained that a declaratory judgment would not bring about any change in his conduct. This court was unmoved by that assertion. The reason is simple. that a prosecutor might eventually find another reason, grounded in Article 64 or elsewhere, to deny a prisoner's request for DNA testing does not vitiate his standing to argue that the cited reasons violated his rights under the Due Process Clause. Finally, Saenz asserts in the alternative that this case is now moot because Saenz refused Gutierrez's request for DNA testing even after the district court issued the declaratory judgment. That claim fails too. As Saenz himself recognizes, a case becomes moot only when it is impossible for a court to grant any effectual relief whatever to the prevailing party. It is not enough that the practical impact of any decision is not assured. In any event, a procedural due process claim like the one Gutierrez presses is not mooted by the defendant's mid-appeal promise that, no matter the result of a lawsuit, the ultimate outcome will not change. Holding otherwise would allow all manner of defendants to manufacture mootness by ensuring that, no matter what procedures a court requires the defendant to employ, the same substantive outcome will result. In that world, the person living adjacent to the site for proposed construction of a federally licensed dam would lose her claim to challenge the licensing agency's failure to prepare an environmental impact statement as long as the agency promised that the statement would not cause the license to be withheld or altered. Article 3 mandates no such result. In the end, Reed is indistinguishable. Gutierrez has standing to challenge Texas's DNA testing procedures under the Due Process Clause. The judgment of the U.S. Court of Appeals for the Fifth Circuit is therefore reversed, and the case is remanded for further proceedings consistent with this opinion. It is so ordered. Justice Barrett, concurring in part and concurring in the judgment. When the Fifth Circuit attempted to distinguish this case from Reed v. Gortz, it failed to consider the breadth of the relief that Gutierrez requested in his complaint. I would reverse on that basis alone. The court goes further, borrowing from our somewhat relaxed redressability inquiry in administrative law procedural injury cases. By invoking Akins and Lohan in the unique context of requests for DNA evidence from Texas prosecutors, the court muddies the waters of standing doctrine. I respectfully join all but Part 2, B2 of the court's opinion. Justice Thomas, dissenting. I join Justice Alito's principal dissent because I agree that Ruben Gutierrez lacks standing to bring a federal suit alleging that Texas's post-conviction DNA testing procedures violate due process. I write separately to emphasize that this court has no business intervening in this case in the first place. The Constitution does not require any state to establish procedures for state prisoners to challenge the validity of their convictions after trial. Yet, Gutierrez's suit rests on the premise that the 14th Amendment's Due Process Clause gives him a liberty interest in Texas's voluntarily created procedures. That premise cannot be squared with any principled reading of the Due Process Clause. I therefore disagree with our decision to grant certiorari and revive Gutierrez's challenge. Our intervention serves no purpose other than to exacerbate the already egregious delays endemic to capital litigation. The Texas Constitution provides capital defendants the right to a trial by jury. It further provides that, after a defendant is convicted and sentenced, he may file a direct appeal to the Texas Court of Criminal Appeals, TCCA, the state's highest court for criminal cases. Texas law also allows prisoners sentenced to death to challenge their conviction and sentence collaterally by filing a petition for habeas corpus in their court of conviction. Even if the prisoner's trial was error-free, he may obtain habeas relief under state law if he produces newly discovered evidence establishing that he is actually innocent. Chapter 64 of the Texas Code of Criminal Procedure further allows convicted defendants to seek testing of DNA evidence that was in the possession of the state during trial. Upon the defendant's motion, the convicting court may order testing if certain conditions are met, including that the evidence still exists in a testable condition, that the defendant can show that he likely would not have been convicted had he obtained exculpatory results from DNA testing, and that the defendant can show that he is not bringing the motion unreasonably to delay his execution. Defendants who obtain DNA testing may use the results to support their state habeas petitions. A Texas jury convicted Gutierrez and sentenced him to death for the 1998 robbery and murder of Escholastica Harrison. Having thrice failed to obtain DNA testing under Chapter 64 in state court, he now claims that several of Chapter 64's restrictions on obtaining DNA testing violate the Due Process Clause of the 14th Amendment. To make sense of Gutierrez's claim, we must first understand what rights the Due Process Clause protects. The clause provides that no state shall deprive any person of life, liberty, or property, without due process of law. In other words, the state cannot decide to take away an individual's life, liberty, or property unless it adheres to certain procedures. But the Due Process Clause does not protect all rights, only life, liberty, and property. Thus, the first step in any due process analysis is to determine whether the right that the individual asserts falls within one of these three categories. If it does not, the requirements of due process do not apply. By seeking to execute Gutierrez and to imprison him until his execution, Texas undoubtedly seeks to deprive Gutierrez of his life and liberty. Yet, Gutierrez rightly does not base his due process claim on either of these deprivations, because he has received far more than the process required to justify them. Under our precedents, Texas must conduct a trial before it can imprison or execute a person as punishment for a crime. But, the state is not required by the federal Constitution to provide a right to appellate review, nor need it provide post-conviction relief, which is even further removed from the criminal trial. Texas thus gave Gutierrez at his 1999 trial all the process necessary to imprison and execute him. The ensuing quarter-century of direct and collateral review has been additional process above the constitutional floor. Gutierrez instead asserts that he has a distinct liberty interest in Texas's state-created right to post-conviction relief. In Gutierrez's view, part of the liberty that Texas prisoners enjoy under the 14th Amendment is a right to obtain release pursuant to Texas's habeas statute, which the state takes away every time its courts deny habeas relief. Thus Gutierrez contends, if Texas law does not afford prisoners sufficient procedural rights to bolster their habeas petitions, such as, in his case, access to DNA testing, the state has deprived them of liberty without the due process of law. Gutierrez bases his asserted interest on Osborne, where the court concluded that a prisoner has a post-conviction liberty interest under the Due Process Clause if state law grants him an entitlement to prove his innocence even after a fair trial has proved otherwise. The 14th Amendment does not protect Gutierrez's asserted liberty interest. As originally understood, liberty in the 14th Amendment likely referred only to freedom from physical restraint. It did not include entitlements to government-created benefits. This court's contrary precedent stems from a conscious, policy-based rejection of the Due Process Clause's original meaning. The original meaning of liberty in the 14th Amendment was likely far narrower than our precedents currently hold. The term originally appears to have referred only to freedom from physical restraint. But, in the Lochner era, the court began to hold that liberty includes fundamental rights generally. This court has since adhered to that broader meaning. As with any legal text, we must construe the 14th Amendment according to the ordinary meaning of its terms at the time of its enactment. We may not defer to demonstrably erroneous precedents that are inconsistent with the amendment's original meaning. When the 14th Amendment was adopted in 1868, its Due Process Clause was understood to embody an old principle dating back to Magna Carta, the great 13th century Charter of English Liberties. Magna Carta provided that a free man may not be prosecuted, imprisoned, or destroyed except by the law of the land. A century later, a statute interpreting this law of the land provision stated that no man shall be imprisoned or put to death, without being brought in answer by due process of the law. Blackstone referred to Magna Carta's law of the land provision as protecting the three absolute rights of every Englishman: the right of personal security, including life, the right of personal liberty, and the right of private property. This formulation heavily influenced the founding generation of America. Many early state constitutions contained provisions that replicated Magna Carta's language, but were modified to refer specifically to life, liberty, or property. And, the Fifth Amendment similarly prohibited the federal government from depriving any person of life, liberty, or property, without due process of law. Liberty in the Fifth Amendment likely refers only to freedom from physical restraint. Blackstone defined the right of personal liberty as the power of locomotion, of changing situation, or removing one's person to whatsoever place one's own inclination may direct, without imprisonment or restraint, unless by due course of law. Following Blackstone, state decisions interpreting state due process provisions between the founding and the ratification of the 14th Amendment almost uniformly construed the word liberty to refer only to freedom from physical restraint. In light of this history, it is hard to see how the liberty protected by the Fifth Amendment could be interpreted to include anything broader. If the Fifth Amendment uses liberty in this narrow sense, then the 14th Amendment likely does as well. When the language of a provision is obviously transplanted from another legal source, it brings the old soil with it. Applying that well-established principle, this court has long recognized the 14th Amendment's due process protections as having the same sense as the Fifth Amendment's. It was not until the Lochner era that this court adopted a broader understanding of liberty. During that period, stretching from 1897 to 1937, this court relied on the legal fiction of substantive due process to invalidate disfavored social and economic legislation by states. Under that fiction, the Due Process Clauses forbade all government infringement on certain fundamental liberty interests, no matter what process is provided. To make the fiction work, the court reinterpreted the clause's guarantee of process to encompass substance, a notion that strains credulity for even the most casual user of words. The court's embrace of substantive due process also required it to jettison the concept of liberty as only freedom from restraint, so that it could encompass other rights that the court deemed fundamental. In Algier, this court's first substantive due process decision under the 14th Amendment, the court for the first time broadened the definition of liberty to include the freedom of contract. By the height of the Lochner era, the court had stretched the term to cover those privileges long recognized at common law as essential to the orderly pursuit of happiness by free men. These privileges included the right of the individual to contract, to engage in any of the common occupations of life, to acquire useful knowledge, to marry, establish a home and bring up children, and to worship God according to the dictates of his own conscience. This court eventually repudiated Lochner's muscular version of substantive due process, at least for economic rights, but the court continues to treat Meyer's definition of liberty as authoritative. Gutierrez's claim of a state-created liberty interest in obtaining post-conviction relief is inconsistent with the original understanding of liberty. From the founding through the Lochner era, liberty was understood to be a natural, pre-political right. Such an understanding is fundamentally incompatible with a right bestowed by the government. Blackstone squarely framed life, liberty, and property as natural rights that existed before government. In an account heavily influenced by the political theories of John Locke, Blackstone explained that, in the state of nature, every man has the power of acting as he thinks fit, without any restraint or control. When man enters into society, he gives up a part of his natural liberty to enjoy the rest of it in security. Thus, the liberty that each man enjoys as a member of society is no other than natural liberty so far restrained by human laws, as is necessary and expedient for the general advantage of the public. This includes the absolute rights of life, liberty, and property, which exist in the state of nature, and which every man is entitled to enjoy whether out of society or in it. In other words, according to Blackstone, life, liberty, and property are rights that predate government and that were not surrendered when government was established. They are not entitlements that the government can bestow by positive law. Founding-era Americans shared this understanding of liberty. The Lockean idea of civil liberty as natural liberty constrained by human law permeated the 18th-century political scene in America. For instance, the Virginia Declaration of Rights of 1776, the first of the colonial bills of rights, proclaimed that all men, by nature, possess the inherent rights of life, liberty, and property, which they retain when they enter into a state of society. Similarly, the Declaration of Independence asserts that the unalienable rights of life, liberty, and the pursuit of happiness come from the Creator, and that, to secure these rights, governments are instituted among men. The understanding of liberty as a natural right persisted until well after the enactment of the 14th Amendment. Even as this court expanded the notion of liberty in the Lochner era, it remained faithful to the idea of liberty as individual freedom from governmental action, not as a right to a particular governmental entitlement. None of the liberties enumerated in Meyer, for instance, could be characterized as state-created benefits. To the contrary, when interpreting the due process clauses, the court distinguished between rights inherent to the individual and privileges established by the government. The court recognized, for example, that a prisoner's statutory entitlement to early release on parole was a privilege that comes as an act of grace to one convicted of a crime, not a right protected by the due process clauses. In short, entitlements established by the government cannot be liberty under the due process clause of the 14th Amendment. Gutierrez thus has no liberty interest in Texas's state-created right to post-conviction relief. Gutierrez rests the legitimacy of his due process claim on Osborne, which concluded that a prisoner has a liberty interest when state law gives him an entitlement to prove his innocence even after a fair trial has proved otherwise. But Osborne did not base this conclusion on the original meaning of liberty in the 14th Amendment. It instead relied on a line of cases ultimately tracing back to Goldberg, where this court relied on policy considerations to redefine property to include government entitlements. Scholars generally agree that the term property in the due process clauses originally referred only to those interests traditionally recognized as property at common law. Property at common law did not include entitlements to government benefits, and, consistent with their general view of civil liberties, Americans at the founding and in the early republic viewed property, like liberty, as a natural, pre-political right. The understanding of property as a natural right persisted through the ratification of the 14th Amendment. After the Civil War, this court held that a statute of limitations defense was not property within the meaning of the Constitution, because it is the creation of conventional law, not a natural right. And, state court decisions in the years leading up to and immediately following the amendment's ratification continued to recognize property as a natural right. Consistent with this view, it has traditionally been held that the due process clauses do not apply where it is possible to characterize the asserted private interest as a mere privilege subject to the government's plenary power. Thus, from the antebellum period to the 1960s, this court consistently recognized that government employment, veterans' benefits, admission to the country as an alien, and other government-created entitlements are not property or otherwise cognizable interests under the due process clauses. In the 1960s, Charles Reich of the Yale Law School published 2 articles proposing a radical reinterpretation of the concept of property. Taking direct aim at the framers' understanding, Reich argued that property is not a natural right but a deliberate construction by society that could be redefined to meet contemporary social needs. In his view, the rise of the welfare state and the dependence it fostered meant that each man cannot be wholly the master of his own destiny. Thus, he concluded, to protect the now dependent citizenry from arbitrary government power, the legal system must make government benefits into rights akin to traditional property rights. In other words, we must create a new property. This court embraced Reich's vision in 1970, holding that welfare benefits are property under the 14th Amendment's Due Process Clause because they are a matter of statutory entitlement for persons qualified to receive them. The court dismissed any distinction between a privilege and a right, and did not attempt to ground its conclusion in the text or history of the Due Process Clause. The court instead gave a sociological justification, simply highlighting the social importance of entitlements, which had come to make up much of the existing wealth in this country, and which only the poor had been theretofore unable to effectively enforce. Soon after Goldberg's radical redefinition of property to include government-created entitlements, this court redefined liberty along similar lines. The court held that, in at least some circumstances, the denial of parole triggered the Due Process Clause because a person's liberty is equally protected, even when the liberty itself is a statutory creation of the state. To justify this shift, the court relied on the accepted due process analysis as to property. As with property, the court's redefinition of liberty was a conscious break with the past. The court rejected the inquiry of whether a parolee's liberty is a right or a privilege as hardly useful any longer. It expressly repudiated its earlier case law holding that probation, as an act of grace, triggers no due process protections. And, seemingly to obfuscate the awkwardness of referring to a government-created entitlement as liberty, the court began to speak instead of liberty interests. Osborne relied on this line of cases to recognize a liberty interest in post-conviction procedures. Invoking the language of Goldberg, the court asserted that a prisoner has a liberty interest in a state's post-conviction procedures if those procedures confer an entitlement to prove his innocence after trial. Osborne thus cannot support Gutierrez's asserted liberty interest. We may, consistent with the judicial power, defer to earlier decisions that apply traditional tools of construction and arrive at different, but reasonable, interpretations of legal texts. But, Osborne rests on nothing more than Goldberg's abandonment of the Due Process Clause's original meaning. We should correct the error we made in Osborne, which seriously undermines states' interests in finality and in providing relief to compelling claims of actual innocence. At the very least, we should cease finding novel ways to revive due process challenges to post-conviction DNA testing procedures, as the court does today. In enacting Chapter 64, Texas has voluntarily chosen to prioritize claims of actual innocence at a significant cost to its interest in finality. Thanks in no small part to decisions of this court, capital cases today are routinely plagued by decades-long delays between sentencing and execution, with much of the litigation concerning convoluted procedural issues having little or nothing to do with the guilt or innocence of the defendant. This delay undermines the important interest that both the state and the victims of crime have in the timely enforcement of a sentence. By recognizing a liberty interest in Texas's post-conviction procedures, however, this court has converted those procedures from a means of vindicating compelling claims of actual innocence into a tool for obstruction. In addition to trial, direct appeal, and multiple rounds of collateral review in state and federal court, Texas must now prevail in yet another arena, Section 1983 litigation challenging its DNA testing procedures, before it can carry out its lawfully imposed sentences. And, given the novelty of this litigation, such suits give rise to a host of difficult threshold justiciability questions that must be resolved before a federal court can reach the merits of the due process challenge, much less before a state court can resolve the prisoner's claim of actual innocence. We need look no further than this case. 26 years after the brutal murder of Escholastica Harrison, this court stayed Gutierrez's impending execution. Why? Not because Gutierrez had made a compelling allegation of innocence. Rather, the court stayed the execution to decide whether Gutierrez has standing to raise a due process challenge to Texas's post-conviction procedures. There is every reason to think that the ultimate claim of actual innocence on which Gutierrez's case rests is baseless. The key premise that Gutierrez hopes that DNA testing will establish that he was not inside Harrison's home when she was stabbed to death with a pair of screwdrivers is contradicted by his own confession, to say nothing of the unanimous statements of his accomplices. The TCCA has held 3 times that Gutierrez would likely still have been convicted of capital murder as an accomplice even if he could prove that he had not personally been inside Harrison's home. And, in Gutierrez's most recent motion for DNA testing, the trial court explicitly found that Gutierrez had made the motion for the purpose of unreasonably delaying the execution of his sentence. In short, Texas could reasonably determine that the need for finality outweighed the upsides of giving Gutierrez additional process. Yet, because this court has found a liberty interest where none exists, that judgment must be thwarted until this additional multi-year front of litigation reaches its conclusion. If this is what states can expect when they create new post-conviction avenues for raising actual innocence claims, they may well conclude that doing so is not worth the cost. Gutierrez's suit rests on a non-existent liberty interest. The Due Process Clause protects an individual's natural liberty from government interference. It does not guarantee entitlements to government benefits, like Texas's voluntarily adopted post-conviction procedures. By intervening to revive this suit, the court facilitates precisely the unjustified delay that it is supposed to prevent in capital cases. That is a misuse of our discretionary certiorari jurisdiction. I respectfully dissent. Justice Alito, with whom Justice Thomas and Justice Gorsuch join, dissenting. The court and I agree on one thing. We should decide this case based on the test adopted in Reed v. Gortz. After that, however, the majority veers sharply off course. First, it blatantly alters the Reed test. Second, it then has the audacity to criticize the Fifth Circuit for applying the real Reed test. Third, it ignores critical differences between the situation in Reed and the situation here. Fourth, it paints a misleading picture of underlying facts and Gutierrez's decades-long litigation campaign. Fifth, it fails to recognize the limited scope of the declaratory judgment at issue. And sixth, it ignores lawful and binding Texas law regarding the facts that may be considered when a prisoner seeks DNA testing. Because the majority paints a misleading picture of the facts and prior proceedings in this case, I begin by setting the record straight. In 1999, Gutierrez was convicted and sentenced to death for the brutal murder of Escholastica Harrison, an 85-year-old woman who lived in a mobile home park in Brownsville, Texas, with her nephew Avel Queller. As a result of his friendship with Queller, Gutierrez became acquainted with Harrison and occasionally ran errands for her. Queller, Gutierrez, and other friends gathered to drink behind Harrison's home, and Queller, while inebriated, revealed that Harrison kept her entire life savings, more than $600,000, in her home because she distrusted banks. When Gutierrez heard this, he hatched a plan to break into the mobile home and steal the money. He recruited two accomplices, Rene Garcia and Pedro Gracia, and on September 5, 1998, the three men went to Harrison's trailer home to execute the plan. By the time they left the scene, Harrison had been beaten and stabbed 13 times in her face and neck with two different instruments. When Queller came home that night, he reported discovering his elderly aunt's dead body face down in a pool of blood. Several witnesses told detectives that they had seen Gutierrez at the mobile home park on the day of the murder. Detectives visited Gutierrez's home but were told he was not there. The next day, Gutierrez voluntarily appeared at the police station and made the first of three conflicting statements. He told detectives that on the day of the murder, he was driving with a friend far away from the mobile home park. This alibi fell through, however, when the friend told a conflicting story. In addition, Garcia and Gracia confessed to involvement in the crime, named Gutierrez as an accomplice, and said he was inside the mobile home when Harrison was killed. Based on these statements and other evidence, Gutierrez was arrested. At the police station, Gutierrez agreed to give a second statement. Abandoning his earlier story, he admitted that he had planned to rip off Harrison, but he claimed that he had not wanted to murder her. He told the police he had been waiting at a park when Garcia and Gracia carried out the scheme. When they later met, he asserted, Garcia was holding a screwdriver covered in blood and said he had killed Harrison. The following day, Gutierrez gave his third conflicting statement. In a signed confession, he said that Garcia was supposed to lure Harrison out of her home so that Gutierrez could enter through the back of the trailer and steal the money, but when Harrison saw Gutierrez enter her home, Garcia knocked her out and began to stab her with a screwdriver. Gutierrez admitted that both he and Garcia were armed with screwdrivers during the robbery. Gutierrez said that he took the money while Garcia was stabbing Harrison and that Gracia drove everyone away from the scene. The state of Texas then charged Gutierrez with capital murder committed in the course of a robbery. Gutierrez moved to suppress his signed confession, arguing that it was coerced and that the police continued to question him after he had invoked his right to counsel and his right to remain silent. After conducting a hearing at which Gutierrez and two police officers testified, the judge denied the motion and issued detailed findings of fact. Gutierrez appealed, but the TCCA affirmed. At trial, the state's theory was that Gutierrez was guilty of murder either as a principal or a party to the crime. The state relied on Texas's law of parties, under which a person is criminally responsible as a party to an offense if the offense is committed by the conduct of another for which he is criminally responsible. Because Gutierrez had admitted to participating in the robbery, the state argued that he could be found guilty of murder even if he was not the one who delivered the fatal blows. Gutierrez's defense offered a version of events that differed from all three of Gutierrez's prior stories. The new account was that Queller had fatally stabbed Harrison. The defense intimated that the police had manufactured Gutierrez's statements and criticized the police for conducting a shoddy investigation. The jury found Gutierrez guilty. At the penalty phase of the trial, the state presented evidence that Gutierrez had a long history of crime and violence, including burglaries, assault on a police officer, and threats to kill an assistant district attorney and a prison guard. The jury found, 1. That Gutierrez posed a continuing threat to society, 2. That he had intended to kill the deceased, or anticipated that a human life would be taken, and 3. That any mitigating circumstance were insufficient to warrant a sentence of life imprisonment without parole. Based on these findings, the judge imposed a sentence of death. Gutierrez appealed and argued, among many other things, that his confession should have been suppressed, but the TCCA affirmed his conviction and sentence. The end of direct appellate review was just the start of a new litigation saga spanning 23 years, and counting. After the conclusion of direct appellate review in 2002, Gutierrez filed multiple petitions for state and federal post-conviction relief, none of which has been successful. And Gutierrez has told us that he intends to file yet another petition for state post-conviction relief. Among the many claims that Gutierrez has advanced in post-trial litigation, the claim involved here, that he is entitled to DNA testing of items found at the murder scene, has a prominent place. At trial, however, his counsel declined to request DNA testing. As recounted by the TCCA, the record affirmatively shows that DNA testing was available to appellant before trial, but defense counsel apparently did not have testing performed on those same items because of sound trial strategy. Instead of risking what testing might reveal, counsel used the fact that the Brownsville Police Department failed to test the evidence containing biological DNA evidence to argue the lack of investigation and the existence of reasonable doubt during the trial. The lack of testing figured prominently in his cross-examination of prosecution witnesses and was repeatedly raised during summation. The decision to forego DNA testing at trial did not pay off, so after his conviction, Gutierrez changed course and demanded testing in post-conviction proceedings. Chapter 64 of the Texas Code of Criminal Procedure governs such requests, and Gutierrez filed his first Chapter 64 motion in 2010. He sought testing of 1. A blood sample taken from Harrison, 2. A blood-stained shirt belonging to Queller, 3. Nail scrapings from Harrison, 4. Blood samples collected from Queller's bathroom, from a raincoat located in or just outside Queller's bedroom, and from the sofa in the front room of the home, and 5. A loose hair recovered from Harrison's finger. According to Gutierrez, the testing would show that he had not entered Harrison's house and would support his position that he neither murdered Mrs. Harrison nor anticipated her murder. The trial court denied this motion, and the TCCA affirmed. The TCCA explained that Chapter 64 authorizes post-conviction DNA testing only when the results would affect the applicant's conviction, not his sentence. And in any event, it explained, favorable DNA results would not undermine the jury's guilty verdict, because they would not make it less probable that Gutierrez planned and participated in the crime. Nor, it added, would such results affect Gutierrez's eligibility for the death penalty because the record facts satisfy the Enman/Tyson culpability requirements, that he played a major role in the underlying robbery and that his acts showed a reckless indifference to human life. Gutierrez filed additional Chapter 64 motions for DNA testing in June 2019 and July 2021, but the trial court denied those motions, and each time the TCCA affirmed on the same grounds. This brings us to the latest chapter, Gutierrez's current suit. In September 2019, Gutierrez sued Cameron County District Attorney Luis Saenz and other Texas officials in federal court under Reverend Stat. Section 1979, 42 U.S.C. Section 1983. Gutierrez asserted several facial and as-applied constitutional challenges to Chapter 64, including a 14th Amendment due process claim, a First Amendment access to courts claim, and an 8th Amendment cruel and unusual punishment claim. The district court rejected almost all of Gutierrez's claims, but the court held that Chapter 64 is unconstitutional insofar as it allows a defendant to seek post-conviction DNA testing to challenge his conviction but not his sentence. The district court entered a partial declaratory judgment for Gutierrez on that ground but did not issue the injunction Gutierrez had sought. The state appealed, but Gutierrez did not cross-appeal, so the only issue before the Fifth Circuit was whether Gutierrez was entitled to a declaratory judgment on the one constitutional claim accepted by the district court. The Fifth Circuit did not reach the merits of that claim because it held that Gutierrez lacked standing. Our test for Article III standing, set out in Lujan v. Defenders of Wildlife, has 3 prongs, and the Fifth Circuit found that Gutierrez failed the third prong. That is, the court found that Gutierrez could not show that his claimed injury, lack of DNA testing, was likely to be redressed by the relief that could at that point be awarded. In Reed v. Gortz, this court recently applied this test under related circumstances. As I will explain, there are critical differences between that case and the case at hand, but there are similarities that seem to have led the majority astray. In Reed, a prisoner sentenced to death, Rodney Reed, brought a Section 1983 action against a district attorney and sought a declaratory judgment that a particular provision of Chapter 64, its chain of custody provision, violates the Constitution. This court held that this declaratory judgment would redress the prisoner's deprivation of DNA testing because it would substantially alter the likelihood of the district attorneys ordering DNA testing. There were multiple issues in Reed, and the court's discussion of redressability was terse. The court held that the prisoner satisfied this test. In other words, the court was persuaded that if he got the declaratory judgment he wanted, it was substantially likely that the district attorney would order testing. The Fifth Circuit faithfully applied this test in its decision below, taking into account the particular facts of Gutierrez's case. It noted that the TCCA has repeatedly held that Gutierrez would still be responsible for the murder under the law of parties and would still be death penalty eligible even if DNA testing provided the results he wanted, and it thus held that a decision in Gutierrez's favor on his constitutional claim would not make it substantially likely that the district attorney would release the items for testing. Today's decision, in contrast, flagrantly distorts the standard that Reed articulated. Indeed, the majority edits Reed's critical language in a way that would draw rebuke if done by an attorney in a brief filed in this court. The majority's analysis is based entirely on the first sentence, which states, "If a federal court concludes that Texas's post-conviction DNA testing procedures violate due process, that court order would redress a prisoner's injury by eliminating the state prosecutor's reliance on Article 64 as a reason for denying DNA testing." The second and third sentences explain why the conclusion drawn in the first sentence was true in Reed's case, because the particular declaratory judgment that Reed sought, striking down Chapter 64's chain of custody requirement, would substantially increase the likelihood that the district attorney would turn over the requested items for DNA testing, but the majority pretends those sentences do not exist. This distortion is bad enough, but to make matters worse, the majority then criticizes the Fifth Circuit for transforming the redressability inquiry into a guess as to whether a favorable court decision will in fact ultimately cause the prosecutor to turn over the evidence. In the majority's view, this court apparently should not consider whether the district court's judgment is likely to result in Gutierrez obtaining relief, but whether the district court's judgment removes just one of the numerous barriers between Gutierrez and the requested testing. The majority's new test makes a hash of redressability. It appears that, under this new test, the likelihood of redress is simply not relevant. That most certainly is not what Reed held. Under the real Reed test, a plaintiff like Gutierrez must show that a favorable decision on his constitutional claim is substantially likely to prompt the district attorney to allow DNA testing. And in this case, unlike in Reed, it is clear that the only relief that Gutierrez is in a position to seek, reinstatement of the district court's declaratory judgment, is most unlikely to cause respondent Saenz to order DNA testing. That is the conclusion that the Fifth Circuit reached after carefully considering the relevant facts, and that court was right. The following part of this opinion will explain why. The Texas courts have provided 3 reasons why Gutierrez is not entitled to the testing he seeks. Any one of these, if sound, would justify the denial of testing. First, both the trial court and the TCCA have held that Gutierrez is not entitled to post-conviction DNA testing, because such testing is unavailable under Chapter 64 to show ineligibility for the death penalty, and Gutierrez could not show by a preponderance of the evidence that he would not have been convicted if he obtained favorable DNA test results. Second, both the trial court and the TCCA have concluded that even favorable DNA test results would not help Gutierrez because he would still be responsible for the murder and would still satisfy the Enman/Tyson Eighth Amendment requirements. Third, the trial court found that Gutierrez's application for DNA testing was made for the purpose of delay. Contrary to the majority's suggestion, a favorable declaratory judgment respecting the first of these reasons, Chapter 64 does not allow post-conviction DNA testing to prove ineligibility for the death penalty, would not remove the barrier Article 64 erected between Gutierrez and the requested testing. It would remove a barrier. The district court's declaratory judgment regarding the constitutionality of Chapter 64's limited grounds for post-conviction DNA testing, even if upheld by the Fifth Circuit and this court, would affect only that reason and not the other two. And even if the TCCA did not accept the trial court's finding that Gutierrez filed his Chapter 64 motion for the purpose of delay, the TCCA would almost certainly adhere to its prior decisions holding that favorable DNA results would not show that Gutierrez was innocent of the crime or ineligible for the death penalty. As a result, the only relief Gutierrez can possibly get in this case would not result in court-ordered testing unless the TCCA reverses course in an utterly unforeseeable way. Gutierrez argues, however, that even if the declaratory judgment would not lead the Texas courts to grant DNA testing, Respondent Saenz would still have discretion to turn over the items and might do so. But Gutierrez does not spell out why Saenz might do that. His argument is based on rank speculation, and that is not enough to support redressability. Furthermore, nothing in the record suggests that there is any likelihood that Saenz would do what Gutierrez wants. The declaratory judgment would not require Saenz to order testing. And he would know that the testing would be pointless because even if the items were tested and revealed what Gutierrez hopes for, the Texas courts would not disturb his conviction or sentence. Not only is there no reason to think that Saenz, for some unknown reason, might nevertheless order DNA testing, but his conduct to date strongly suggests the opposite. Even after the district court issued its declaratory judgment, he refused to order testing. And Gutierrez cannot explain why Saenz has steadfastly declined to allow testing ever since. If he had any inclination to allow testing, he could have done that at any point during this litigation, for example, when Gutierrez filed his petition, when this court granted review, at any point during the briefing process, before or after argument, or yesterday. Not only has he not done so, he has steadfastly maintained that he will not do so. His position is that this case should be dismissed. Unable to explain why affirmance of the district court's declaratory judgment might change Saenz's mind, the majority contends that a favorable decision on other constitutional claims asserted in Gutierrez's complaint might do the trick, and it criticizes the Fifth Circuit for basing its assessment of redressability on the declaratory judgment the district court later issued, rather than Gutierrez's complaint. This reasoning is fundamentally wrong and, if allowed to stand, will corrupt our Article 3 case law. Our standing requirements persist throughout all stages of litigation. The constitutional claims on which the majority relies were rejected by the district court, and Gutierrez did not appeal that part of the judgment. As a result, the best relief that Gutierrez could now obtain in this case is an affirmance of the district court's declaratory judgment, and for the reasons already discussed, that relief would not make DNA testing substantially likely. For all these reasons, Gutierrez cannot satisfy Reed's real test for redressability. The majority treats this case as indistinguishable from Reed, but that is not correct. An examination of the situation in that case provides a clear explanation for the Reed court's conclusion that its test for redressability was met. And once that is understood, it is clear that the present case is different. Rodney Reed was convicted and sentenced to death for the murder of Stacey Lee Stites, whose body was found partially clothed and abandoned near a backcountry road. Based on an examination of her body, the police concluded that she had been sexually assaulted and strangled with a belt found at the scene. DNA found on semen in Stites' body matched Reed's genetic profile, and Reed was subsequently arrested and charged with her murder. At trial, Reed argued, among other things, that he and Stites were in a romantic relationship, that they had engaged in consensual intercourse, and that the real culprit was Stites' fiancé, Jimmy Fennell. The jury was not persuaded, and Reed was convicted of capital murder and sentenced to death. Reed filed a Chapter 64 motion seeking DNA testing of the belt and more than 35 other items that were found either on Stites' body, at the scene of the crime, or in or near the truck she shared with Fennell. Applying Chapter 64, the TCCA ruled out consideration of evidence that fell into either of two categories. First, the TCCA refused to consider 21 items on the ground that they did not satisfy Chapter 64's chain of custody requirement. Among these were the strap and buckle from the belt with which Stites had apparently been strangled. Second, the TCCA excluded other items on the ground that they were not reasonably likely to contain biological material suitable for testing. 8 items remained for the TCCA to consider, and 5 of them were found in or near the truck, not at the crime scene. The court then found that favorable results with respect to these 8 items would not have shown by a preponderance of the evidence that Reed was not guilty. Once the role that the chain of custody rule played in the TCCA's analysis is understood, the support for this court's redressability finding in Reed is easy to understand. The declaratory judgment that Reed sought, striking down the chain of custody rule, would have critically undermined the TCCA's holding with respect to the potential impact of DNA testing. 21 additional items, including the belt, could have been considered. If Fennell's DNA, but not Reed's, had been detected on the belt and perhaps other items found at the scene, that would have provided significant support for Reed's theory that Fennell was the murderer. As a result, the declaratory judgment might well have led to a state court decision ordering DNA testing, and that possibility would have given the district attorney a reason to turn over the items even before such a state court decision was handed down. The result would have been a significant increase in the likelihood that the state prosecutor would grant access to the requested evidence. In response, the majority argues that even if the chain of custody rule was held to be unconstitutional, the district attorney could have denied Reed's request for another reason. That is true, but beside the point. Under this court's decision in Reed, all that was required to show redressability was a significant increase in the likelihood that the district attorney would allow testing. Gutierrez's case presents a far different situation. Here, the TCCA has held that, even if DNA testing failed to detect Gutierrez's DNA and detected the presence of Queller's DNA, Gutierrez could not establish that he was not guilty of murder, or that he is ineligible for a death sentence. The TCCA noted that, since Queller lived with Harrison in the same trailer home and was the person who found her dead body, detecting his DNA on many items in the house would not necessarily be incriminating. And more important, even if Queller's DNA was detected on the most important items, such as the material found under Harrison's fingernails, that would be of little value to Gutierrez. It would suggest that Queller was one of the individuals who stabbed Harrison, but that would not affect Gutierrez's culpability or his sentence. Whether the fatal blows were administered by Garcia, Gracia, Queller, or some combination of these men, Gutierrez would still be guilty of murder under the law of parties because he participated in the scheme. And because he had reason to know that the execution of his scheme could well result in the loss of life, he would still be eligible for the death penalty. Thus, a favorable decision on Gutierrez's constitutional argument would not bolster his challenge to his sentence. Gutierrez responds that favorable DNA results might change the TCCA's thinking because that court's holding on the effect of DNA evidence did not take into account newly discovered evidence that he wants to introduce. The majority suggests that, in assessing whether Gutierrez's injury of not receiving DNA testing is redressable, the Fifth Circuit should have considered Gutierrez's assertion in his complaint that favorable DNA results along with the new evidence could render him ineligible for the death penalty. But the TCCA has held that only evidence in the trial record may be considered in determining whether post-conviction DNA testing is allowed. We have no basis for disregarding that limitation here. We are, of course, bound by the TCCA's interpretation of Texas law, and no question regarding the constitutionality of this feature of Texas law is now before us. Not only does the majority's redressability analysis take into account evidence that this binding state law rule excludes, but the majority seems to think it is relevant that Gutierrez has long maintained that the police coerced him into confessing that he was in Harrison's home on the night of the murder. The majority does not see fit to mention that the state courts have definitively rejected Gutierrez's argument that the confession was coerced, that Texas law would almost certainly bar him from raising the same claim again in a post-conviction proceeding, and that the federal habeas statute would likewise bar consideration of the claim. This decision's only practical effect will be to aid and abet Gutierrez's efforts to run out the clock on the execution of his sentence. And if the decision is taken seriously as a precedent on Article 3 standing, it will do serious damage. I therefore dissent. Thanks for listening. This podcast is not affiliated with the United States Supreme Court or its staff in any way. The summary of this opinion given in the introduction was taken from the summary provided at oyez.org. Any mistakes in the opinion you just heard should be attributed to this podcast. If you would like to support my efforts to make Supreme Court opinions available to the public, please subscribe. Thank you.